Right. Hello, welcome everyone to Landmark Chambers Nationality and Borders Act Part 2 webinar. We're really pleased to see so many people join the session today. My name's Buley QC. I'm chairing the session today. I've got three colleagues who are going to be doing the hard work of presenting talks, and I'll come to them in a tiny bit more detail in just a moment. Just some very boring practical housekeeping points. You'll probably know all of these, heard all this sort of thing before. Your microphones are automatically muted. You don't need to adjust your settings in any respect. We're very much welcome questions, but please submit them via the chat function. Given the numbers of people, 100 and counting, we've got that it's not practical to have people on the screen. I think they'll break the link or whatever. It's up to you. If you want to remain anonymous, please do so. I think there's a box that you can tick as you submit your question. Obviously, no need to do so. I'll assume that if you haven't ticked the box, then you're happy for me to name you and thank you for the question. The webinar is recorded, so please be aware of that. You'll get a link to the presentation later on, and obviously it'll be publicly available. I hope that doesn't cause a problem for anyone. If your connection is lost at any time, you should be able to just rejoin via the original, but via the same link. Okay, so this is part 2 of our seminar on the new Nationality and Borders Act 2022. Many of you, I suspect, will have attended last week's session, which I was originally supposed to chair, but I couldn't for personal reasons. And you'll have heard already something about the new Act. I won't say very much about it in general. I'll let the speakers speak to their particular topics, but it is a pretty radical and far-reaching piece of legislation. It changes certain aspects of asylum law in particular and related areas like age assessments and trafficking, which are often associated with asylum, in really quite radical ways, in ways that make it unrecognisable would be overstating it, but ways that totally transform what I'd understand to be pretty settled principles about the standard of proof and so forth in the period that I've been in practice, which were probably established around about the time I started, not I hasten to add by me. So it's pretty radical stuff. Whether it's justified is a matter which we might get into at the end, or the speakers might get into. I shall restrain myself a little bit from expressing my own views about this legislation. But in any event, we're going to hear from 3 excellent speakers on the particular topics. So first of all, we're going to have Admas Habteslasie. Admas specialises, among other things, in property law, but also more pertinently to us in human rights and public law and international law, with strong interest, I think, in immigration and asylum, among other things. He's been involved in some very important seminal human rights related litigation, including, for example, on the Chagos Islanders, which I think he might be touching on in his talk. He's going to be talking about the nationality provisions, very controversial as they've been in the press. So he's going to be talking to us about that. Secondly, I think, if I got the order right, it's going to be Joe Thomas. He's a relatively new member of Chambers, already making waves, practices in public planning, environmental and education law, particular interest, I think, in education law, as well as the sorts of issues we're going to be talking about today around immigration and asylum. Already has a substantial practice, especially including in the High Court. And lastly, Miranda Butler is a very welcome new addition to Chambers. She's joined us from Garden Court. She specialises, she'd be perhaps very well known to some of you, she specialises in immigration and asylum related issues, amongst other areas of public law, and has appeared in some very important cases in that area, including, I noticed, the recent nationality case in the Supreme Court. And she's going to be, she has a particular interest, well, she has many interests, but she has a lot of experience of trafficking law, and she's going to be talking to us about that. Sorry, I don't think I said what Joe was going to be speaking about, but you already know it's age assessments. So without further ado, thank you. I will hand over to Admas, and you'll hear from me at the end when we'll be taking some questions. Thanks very much.
Thank you very much, Tim, and good morning, everybody. So as Tim mentioned, I'm going to be speaking about part 1 of the new act and providing an overview of the nationality provisions. The structure of my talk is set out there, so I'll just do a very quick introduction to different nationality statuses which come up. Then I'll just go through the provisions dealing with British overseas citizens and historic issues, which make up probably the majority of part one. Then I'll say something about the deprivation of nationality provisions, which are probably the most controversial and starkest provisions in this part of the Act anyway, and then just provide and an oversight of the various other provisions in part one. I'm not proposing to go into this in a lot of detail, but I've just set out there a timeline of the various different nationality statuses that there have been in British nationality law, starting with the British subject before the 1948 Act, then citizenship of the UK and colonies. So just dealing with those parts of Her Majesty's dominions, as they were termed, which excluding those which became independent. And the subsequently we see the division between British citizens proper and then nationality statuses relating to what were called British dependent territories and currently British overseas territories. And that context is useful to note for those less familiar with the intricacies of nationality law, because quite a few of the provisions in the Act in Part 1 deal with British overseas territories citizens. So that's the genealogy of that concept there in brief. So the practical difference between a British overseas territories citizen and a British citizen is essentially that the British overseas territory citizen has no right of abode or right to work in the UK. They're still subject to immigration controls, but they do hold a British passport and have access to consular assistance and protection. So let's turn then to the provisions of the Act. Sections 1 and 2 introduce new provisions into Part 2 of the 1981 Act. And what these provisions do is create right to register for persons who would have satisfied the requirements for registration as a British overseas territory citizens, but for the fact that their mother could not transmit citizenship, or the fact that their mother was not married to their natural father at the time of their birth. So prior to these amendments, that would have precluded the entitlement to register, and essentially the effect of these new provisions is to reverse that discriminatory effect, essentially. So those persons are now taken to satisfy the relevant requirement and are entitled to be registered as British overseas territory citizens. There's a new provision dealing specifically with persons connected to the Chagos Islands / British Indian Ocean Territory. For those unfamiliar, there's a picture there showing roughly where that is located in the South Indian Ocean. And the background is that the British Indian Ocean Territory is composed of two groups of islands, and most of them were administered until 1965 as part of the Mauritian colony, and then controversially detached into a separate colony along with some islands from the Seychelles. The Chagos Islands, so the bit that came from Mauritius, had their entire population expelled to make way for a US naval base in the early 70s on the largest island, Diego Garcia, and then the return of those people was prohibited by immigration ordinances. Those who are familiar with the issue will know that it's generated a significant amount of litigation, domestic courts, European Court of Human Rights, and in the ICJ, I'm involved in some domestic litigation, and there's an application outstanding to the European Court of Human Rights on that. So the new provision in section 3 is to insert a new section 17H, which provides for a right to register as a British Overseas Territory citizens for a person who is a direct descendant of a person who was a citizen of the UK and colonies by virtue of their birth in the Buyout and has never been a British Overseas Territory citizen or British Dependent Territory citizen. And essentially what this provision is aiming to deal with is the fact that had the British government not expelled and made it impossible for these people, expelled these people from the islands and then made it impossible for them to return, then they would have had entitlements to acquire the various nationality statuses, currently the British Overseas Territory citizen status, not just for themselves, but also for their dependents. So it is to some extent seeking to reverse the effect of the Foreign Office's policies that took place in that period. There are some interesting legal issues in the background. I think it's probably questionable in practice whether anybody's going to be challenging what is essentially a grant of rights by the state. But just to set the scene, there's a lease of the largest island, Diego Garcia, to the United States, on which the naval base is located, and that continues until 2036 as the current arrangement. And in 2019, the International Court of Justice gave an advisory opinion where it essentially said that the UK's administration of those islands is unlawful in international law, and the repercussions of that for various aspects of the UK's relationship to the islands are still really being worked through. The UK's public position is that when the UK, i.e. the US, no longer requires the buyout for defence purposes, it will cede the territory to Mauritius. And Mauritius has also made it clear to the US that it's happy for the US to continue to use the territory as a naval base if and when it takes sovereignty, so to speak. And in the litigation that I've been involved in, the Court of Appeal has queried whether the UK government could decide, for example, to resettle the Chagos Islands in light of the ICJ opinion. So there are some questions about the lawfulness of the UK's responsibility for that particular overseas territory. So moving on then to some of the changes made in relation to deprivation of nationality. As I mentioned, these are particularly stark changes being introduced. So just to set the scene a little, there are two provisions essentially in the 1981 Act currently, which allow for deprivation. The conducive grounds deprivation, that's in subsection 2, which provides that the Secretary of State may deprive a person of citizenship status if satisfied that deprivation is conducive to the public good. And it's normally that's relied on for in the national security cases, which in relation to which there's been some particularly high profile litigation recently, most notably the Begum case. And there's also subsection 3, which provides for a power to deprive citizenship status, which resulted from registration or naturalization, if the Secretary of State is satisfied that that was obtained by means of fraud, false representation, or concealment of a material fact. So those are the substantive powers. And of particular importance for the amendment, for the new provisions being introduced, is subsection 5, which imposes notice requirements that must be met before the Secretary of State can make an order. So the Secretary of State must give notice of the order the reasons for the order and notification of the statutory right of appeal. That's the statutory context. I think that there's a couple of decisions by the courts which seem to me to be also of particular interest in setting the scene for what the Act is doing. First is the Begum case, which was obviously a very high-profile piece of litigation, which ended in success for the Secretary of State appealing against the Court of Appeal. And one of the points that the Supreme Court made in its judgment is it essentially told off the Court of Appeal because it said that the Court of Appeal was wrong in concluding that when an individual's right to have a fair hearing of an appeal came into conflict with the requirements of national security, that the right to have a fair hearing must prevail. That appeal was all about whether Ms. Begum should be allowed back into the UK to participate in her appeal against the deprivation of her nationality. And essentially, the Supreme Court was deprecating the Court of Appeal's approach to the importance of national security as a factor when weighed against the right to a fair hearing. The second piece of context that I think is of some interest here is some litigation which is actually currently on appeal to the Supreme Court, but it's a case called D4, and it is all about a regulation which provided that notice for the purpose of subsection 5 would be deemed if it had been placed in the Home Office file of the person concerned. So essentially it was a way of watering down what subsection 5, the notice requirement, required as a matter of law. That provision was held to be ultra vires, the 1981 Act, by the Court of Appeal quite recently. And the Court of Appeal also made the point that the dispensing with service was inconsistent with the constitutional principle that there needed to be notice of a decision for it to have effect, and that Parliament hadn't legislated expressly contrary to that. So that's against that context, what we see in section 10, subsection 2, is some new subsections introduced into section 40 of the 1981 Act. And the central provision is 5A, which provides that subsection 5, the requirement to give notice before making a deprivation order, does not apply if the Secretary of State does not have the information needed to be able to give notice under that subsection, or the Secretary of State reasonably considers it necessary in the interests of national security, investigation or prosecution of organised or serious crime, preventing or reducing the risk to the safety of any person, or interestingly, the relationship between the United Kingdom and another country, that notice under the subsection should not be given. So it introduces a discretion essentially for the Secretary of State to dispense with service, similar to what was being aimed for with the regulation that was quashed in D4, but on somewhat broader grounds. It also introduces, the Act also introduces a new Schedule 4A into the 1981 Act, which provides for certain procedures around a decision to dispense with service. And the long and short of it is that when the Secretary of State makes a conducive grounds deportation order, so for subsection 2, without notice, then the Secretary of State is obliged to apply to SIAC, to the Special Immigration Appeals Commission, tasked with jurisdiction over appeals in these matters. And essentially, the SIAC asks, was the Secretary of State's conclusion that those criteria for dispensing with service are met, irrational, have those criterion, has the criterion that the Secretary of State relies on been met? There's also an obligation on the Secretary of State to review every 4 months whether the requirements for dispensing with service are still being satisfied, so to speak. But the focus is very much on those statutory criteria. The provision, section 10, the new subsections inserted, also state that a duty will arise to give notice as soon as reasonably practicable, but only if, so in a situation where service has been dispensed with and the person then makes contact with the Home Office, then there is a duty, one would hope, to give notice as soon as is reasonably practicable. Another thing that section 10 does is that it introduces by subsection 6, or it provides by subsection 6, that a failure to comply with the duty under subsection 5 in respect of a deprivation order that's been made pre-commencement does not affect and is to be treated as never having affected the validity of the order. So it, and that is a provision that comes and has already come into force. That came into force. It's one of the few provisions that came into force on the passing of the Act. So even before commencement, essentially, the Act shuts out challenges on the basis that the notice requirement hasn't been complied with in terms of challenges to the validity of the order on that basis. I think it hardly needs observation that it's a pretty stark provision, pretty stark set of changes, and the power to dispense with notice appears to raise rule of law issues, procedural fairness issues, and Article 6 issues, because the Secretary of State is essentially being given the power to deprive somebody of their nationality without needing to tell them about it. And the grounds are broadly framed. National security is perhaps less surprising. It may be that the government has taken the view in view of the approach in cases like Begum that the courts might take an approach to judgments on the basis of national security that affords them a little more primacy than they might have been afforded in the past. But for example, the ability to dispense with service on the basis of the relationship between the United Kingdom and another country. So presumably that would be in a situation, or that certainly could be in a situation where no national security issues arose, but simply on the basis of interstate issues. That appears to be potentially problematic, and one can see an interesting question arising as to how and when the consideration of that kind could be said to outweigh the right to notice, the right to fairness, and to being aware that your rights are being interfered with in a very serious way, that your nationality is being taken away from you. So no doubt we'll be seeing some litigation in relation to that provision at some point. That's nationality, and I've just summarised here some of the other provisions, which I'll go through quite quickly. So section 4, relating to the provisions we looked at the beginning, provides for a right for persons to be registered. So a right for persons who are entitled to be registered as British overseas territory citizens under those new provisions to be registered as British citizens. Section 5 makes an amendment to Section 17 of the 1981 Act to essentially harmonise the period within which a child can apply to be registered as a British Overseas Territory citizen with the period that a child could apply for a British citizenship. So it was 12 months, it's now essentially while they're a minor. Section 7 amends the 1981 Act to provide them entitlement to British citizenship for individuals who are unable to acquire it because their mother was married to someone other than their biological father. And that essentially remedies the problem in the case of K, where that aspect of the statutory scheme was found to be unlawful discrimination. Section 8 provides for a discretionary power to register adults. The current discretionary power to register is only in relation to minors, where in the Secretary of State's opinion, the applicant would have been a British citizen or a British Overseas Territory citizen had it not been for historic legislative unfairness, an act or omission of a public authority, or exceptional circumstances relating to the applicant. Section 9 and also Schedule 1 introduced amendments to the 1981 Act to give the Secretary of State power to waive certain requirements in considering applications for naturalisation. And Section 11, which I expect may also prove to be a controversial provision, deals with stateless minors and introduces a requirement that a child, a stateless child aged 5 to 17 will not qualify for registration as a British citizen if they could reasonably acquire another nationality. And what's meant by that is set out in the new subsection 2. That is where the nationality is the same as that of one of the person's parents. The person has been entitled to acquire that nationality since birth, and it would be reasonable to expect the person to take steps to do so. And that's another provision together with the deprivation provisions, which appears to perhaps widen the gap between categories of British citizens with other nationalities or access to other nationalities and those without. So that brings an end to my summary of part 1 of the Act. I look forward to any questions later, and I'll hand over to Joe now to deal with age assessments.
Thank you very much. Good morning. So I'll be addressing the part 4 of the Nationalities and Borders Act 2022, which considers age assessments. But I think it's probably just worth putting that in context, in the sense that the aim of part 4 is to bring age assessments within the statutory immigration system. So previously, this is an area of law that had developed predominantly in response to litigation and case law, and that's why we have such things as Merton hearings. But it's also worth bearing in mind the context of part 4 is why it's so critically important to get this right. Because if you're detaining very young people, that's only allowed under the immigration rules in very exceptional circumstances. And equally, it's for obvious reasons, there's an enhanced risk of re-traumatizing young people if they're detained. And obviously, when you're dealing with young people, then there are obligations under Education Acts and Social Security Acts and social care rights that arise. Alternatively, on the flip side, there is obviously safeguarding risks of if adults are treated in the same way as children, although there is some evidence to say that that risk has been overplayed. And when you're trying to balance those competing risks, the more important is the risk of re-traumatizing young people. So just to give you some structure for my talk, first of all, I'm going to touch upon how the structure of part 4. I'm going to work through a couple of the key definitions. Then I'm going to talk about the 2 assessments under part 4, section 50 and section 51. Then I'm going to touch upon scientific methods, then the power of the Secretary of State to make regulations, and then dealing finally with appeals, and then some questions that arise from the part 4 as it's drafted. So part 4 has got about 8 or 9 active provisions. works through section 49, includes your key definitions. You've got your 2 assessments under section 50 and section 51. Then section 52 covers the use of scientific methods. Section 53 is how to make regulations. Sections 54, 55 cover appeals. Section 56 covers the circumstances of new information. And then section 57 extends legal aid to age assessments. So dealing with those key definitions, at the core of this is the introduction of a concept of an age-disputed person. So that's an individual who requires leave to enter the UK, a local authority or another public authority, same definition as Section 6 of the Human Rights Act, or the Secretary of State, has insufficient information to be sure of their age. Now, I've touched upon this in the key points section of this slide, but what does sure mean? I mean, how sure is sure? If you're sure that the person is not a child, so you probably look at me and think, that's not a child, you might not be able to guess my age exactly. Am I an age-disputed person? Obviously, a purposive approach will say probably not, but at the moment, there's a little bit of a gap or an ambiguity in the Act as it stands at the moment. And whether or not someone where you're not sure of their age, but suspect they're definitely not a child, would fall within this fall within the definition of an age-disputed person. The other second key definition comes up is something called a designated person, and that's an individual designated by the Secretary of State to conduct an age assessment. At the moment, another gap, which will probably be filled in by regulations, is what qualification or what experience would this designated person have to have, and what would the impact of having a designated person who didn't fulfill those qualifications? Again, a possible gap in the regulations. So we come to the 2 assessments. So there's an assessment under section 50 and an assessment under section 51. And a section 50 assessment occurs when a local authority needs to know the age of an age-disputed person. So that might deal with the issue of whether or not I, for example, would be fall under this, because you might not necessarily need to know my age. Or the other way that section 50 is engaged is the Secretary of State notifies the local authority that it or she doubts the age of an age-disputed person, that the LA has exercised functions under children's legislation, i.e. Secretary of State believes that a person that the local authority has designated as a child isn't in fact a child. Now, when either of those 2 precipitating events occur, local authority needs to know the age, the Secretary of State notifies the local authority, then the local authority must, so it's obligatory, respond in one of 3 ways. Refer the age-disputed person to a designated person, i.e. hand it over to the Secretary of State, conduct an age assessment themselves, or that confirm that an age assessment is not necessary in their view. So one of the critical things that emerges from section 50 is that local authorities will still be playing a vital role in undertaking age assessments. The Secretary of State hasn't used this as an opportunity to completely take over this area of immigration law. So under section 50, when the designated person does an age assessment on behalf of the Secretary of State, that result is binding on the local authority, but not the other way round. And when a local authority conducts an age assessment or confirms that one is not necessary, it must provide evidence to the Secretary of State when requested, so that the Secretary of State can consider the decision. So that led me to thinking about what key points that emerges. So what happens when the local authority gives an age-disputed person an age that the Secretary of State dispute? Does the Secretary of State have the, when instructed to, when the Secretary of State says to the local authority, you need to age assess this, I dispute this, the age given to this person, the local authority then says, does an age assessment itself and says, no, it's fine, they're still a child, or says there's absolutely no need for an age assessment. At the moment, it's not entirely clear what the Secretary of State does in that situation. Again, it's not entirely clear what the Secretary of State will be doing by considering this. Now, the other key issue here is the standard proof is balance of probabilities, but it doesn't actually stipulate what the burden of proof is. So is it for the Secretary of State to prove their age, or is it for the young person to prove their age? And then under the UN Rights of Child Convention, it's very clear that a child is meant to be given the benefit of any doubt, which may have an impact on where the burden of proof lies. And there's a further issue that if, as it states, the age assessment is binding on the local authority, what would happen in the circumstances where the Secretary of State says that someone is a child and the local authority's obligations kick in, providing education, etc., but they severely doubt that the young person is a child? There doesn't seem to be a mechanism for the local authority to challenge the Secretary of State's decision. Then we get on to the Section 51 assessment. So there's Section 50 assessment and Section 51 assessment. And that applies when the Secretary of State needs to make a decision about immigration functions in relation to that person. And a Section 51 assessment can be taken where the Section 50 is not relevant. I'm not entirely sure what sort of factual scenario that would come under, or before a local authority has referred an individual to the Secretary of State, or if the Secretary of State doubts the judgment of the local authority. Now, the Section 51, as it's worded at the moment, is binding on the Secretary of State for immigration functions. But it doesn't seem to be binding in terms of other functions if it's taken under Section 51. Again, this is a potential gap that may need to be reconciled by resolutions or later amendment. So the key point is Section 51 appears to allow the Secretary of State to call in a decision. It is not binding regarding the LA functions on the face of the legislation. Could the LA find the individual child, but the Secretary of State an adult? Again, there's a little bit of a gap there in the legislation as it stands at the moment that may need to be reconciled through litigation. So Section 52 contains the most controversial elements. And this is about scientific methods. And I think the key thing to place in context, and anyone that has done any age assessment work will know this, age assessments are exceptionally hard. Generally, day to day, it is exceptionally difficult to just look at someone and work and guess their age accurately. But there are also different factors in that cross-racial age assessments are particularly hard. You're dealing with young people that have been through trauma, so may adapt adult-like behaviours to screen or shield or hide from to deal with their trauma. How should that be dealt with? Now, the Secretary of State's proposal is to include a scientific method, and scientific method is defined under Section 52.2 as including imaging technology, although that itself is not further defined. Does that include X-rays, for example, or the use of any ionizing radiation? And then analysis of DNA derived from cells, saliva, other samples. Again, we're beginning to wonder, what does that actually mean in practice? That's something that's going to have to be clarified through regulations or guidance. Before the Secretary of State can adopt a scientific method, there's the Section 52 says the Secretary of State must seek scientific advice before deciding whether or not that method is appropriate. But you can see under the key points, there's some questions that arise under that. Who has to be consulted? What if there is no scientific consensus? Does the Secretary of State need to just merely seek scientific advice, or is the duty going beyond that and to seek and then consider or act in accordance with scientific advice? What if the scientific advice comes back, the Secretary of State doesn't like it or doesn't give the clarity or the certainty that they were seeking? Will that be, or states that you can never you can pin down someone's age using a scientific method? It's going to be very interesting how this plays out in practice. Now, the other half of Section 55, is how it deals with consent. And it's very interesting here because it says a scientific method can only be used with appropriate consent. Now, that sounds reassuring in the sense that you're not going to have the state imposing itself on individuals and subjecting them to assessments and tests without their consent, respecting the integrity of the individual. But then, under Section 55(7), and I've copied it out in full because I think there's a couple of key phrases here. In deciding whether to believe any statement made by or on behalf of an age disputed person that is relevant to the assessment of their age, the decision maker must, so it's not obligatory, must take into account as damaging, so it's not, it has to be considered as damaging to the age disputed person's credibility, the decision not to consent to the use of a specified scientific method. So therefore, there's sort of sword of Damocles hanging over people who are subject to an age assessment scientific method, saying you have autonomy and you have choice, but when the decision maker is obliged to treat any statement you say as less credible if you don't consent to, if you don't then subsequently consent to the scientific method. This is very likely, I suspect, to lead to litigation. There's a further provision under section 55.9, which is has implications regarding safeguards that does not prevent the decision maker from using another scientific method if they consider it appropriate. There may be other reasons that they can't use that scientific method. Now, taking a step back, during the passage of this bill, the BMA was clear that X-rays were unethical. They state the use of ionizing radiation for age assessment involves direct harms without any medical benefit to the individual. And as such, we do not believe it would be appropriate to expect doctors to participate in such a practice. The argument being there that scientific methods might reveal information for immigration purposes, but it would deliver no medical benefit, and therefore it would be unethical to expose an individual to the risk arising from ionizing radiation. I did some research to see how other countries have used scientific methods, and it seems to be mostly most established in Sweden, where they use two methods, and they use dental X-rays, wisdom teeth, and an MRI scan of the femur bone. Now, but what's critically interesting about what happens in Sweden is they use these assessments not to provide an exact age, but to give an indication of the probability that an individual is under 18, and it's not to provide an exact age. And the information that I saw from my research says that the accuracy of these assessments has been doubted, and whether or not they actually add any precision has been highly questioned. Council of Europe and the UN Human HCR both state that scientific methods have substantial margins of error, i.e. 2 years either way, whilst the British Association of Social Workers state that there are no more accurate than informed Merton assessments. So again, it's going to be very interesting to see how this plays out, because there seems parallel tracks in terms of political imperative to deliver certainty, but the scientific advice may be that that certainty is simply not available. So turning on to the power of the Secretary of State to make regulations, and that's under section 53. Now, this is, again, like much of the Act, is couched and framed in very broad terms. But what I thought was particularly interesting from section 53 and the power of the Secretary of State to make regulations is that the regulations can specify what evidence is to be considered and the weight that is to be given to that evidence. And in addition, the consequences of lack of cooperation with any assessment of an age-disputed person, which may include damage to the person's credibility. So there seems to therefore be the power, not necessarily to be exercised, is to front load evidential assessment in circumstances where an individual's credibility will be a fact-specific case that will need to be considered in all the circumstances. And it will be interesting to see how it's played out, and I suspect it will go to litigation, is how that front-loading or preempting of evidential considerations actually can be reconciled with an individual's case, where there may be exceptional circumstances, there may be different considerations, and whether or not front-loading or pre-weighing considerations is compatible with Article 6. Then we get on to appeals, and these are more of an administrative part of the provision. So the right of appeal is now to the first tier tribunal, which critically, if an appeal is made to the first tier tribunal, they must, not may, but they must assign the individual a date of birth. And then anyone that's worked with age assessments across a broad range of cultures knows that that can actually be particularly challenging to assign a specific date of birth for an individual. If the individual leaves the UK, then their appeal is abandoned. Pending the outcome of the appeal, the person is to be treated at the age they claim to be. And we all, that's going to play out it'd be interesting how that plays out, bearing in mind that some of these appeals, bearing the weight and the body of evidence that's required for them, and the cross-examination and the time it takes to arrange them, can be for quite substantial periods of time that an individual will be assumed to be the age that they claim to be. Any decision by the first-tier tribunal is binding on the local authority in the Secretary of State. And then under Section 56, a fresh age assessment must be undertaken on receipt of significant new information. And then that's further defined as information that provides a realistic prospect that would change the outcome of the original age assessment. Again, that strikes me as a potential avenue for litigation and further appeals. Section 57 extends legal aid to the age assessments brought in under Part 4. So there are obviously potential challenges here. We're talking about invasiveness required for scientific assessments. There's potential for re-traumatizing arising from the age assessment itself. So this strikes me as there's an obvious possibility of challenges under at least Article 3 and 8 of the European Convention of Human Rights. In addition, as I've mentioned, that front loading of weighting, that would again possibly give a rise to litigation under Article 6. And then finally, in summary, there's an awful lot still left to be clarified arising from Part 4. You can see the aspirations behind it, but the detail, how it's going to work in practice, hasn't been specified yet. We don't know what it's going to look like. We don't know what extent they're going to be scientific, how that's going to be balanced by a social worker's holistic assessment, or whether or not presumption is going to be given to the scientific ones, how that's going to work in practice. In addition, we don't know how the obligations towards an individual arising from the fact that an age assessment itself can be quite a traumatic event. And this was picked up by the Refugee and Migrant Children's Consortium during the passage of the bill through Parliament. Many young people do not understand the process and feel humiliated and damaged by it. The process itself has the potential to be quite re-traumatizing and impact children and young people's sense of identity. So there's going to be possibly further litigation now that this has been placed on a statutory footing and an obligatory statutory footing about whether or not there's sufficient scope to balance the interest of a young person being subjected to a potentially traumatic age assessment against the interest of the state in ascertaining their age. So essentially, there's still likely to be a rich source of litigation under at least Articles 3 and 8, and I suspect Article 6 as well. However, once this all comes out in the wash, we may find ourselves essentially in the situation we are now, where an age assessments may continue to be social worker-led and will likely still have to comply with Merton guidance. So there may not be that much change in practice. So my parting thought is there's a rich source of litigation here. There's also a lot we don't know about how it's going to work in practice. I'm going to hand over to Miranda.
Thank you very much, Joe. So I'm going to talk about Part 5 of the Act, and in particular, the significant and wide-ranging changes that have been made to the provisions for victims of trafficking. I'm not going to talk about absolutely everything in Part 5, and I've set out the key provisions here. It's perhaps worth starting by noticing quite how radical it is within this context of the law to be putting so much on a statutory footing. We've had a really minimal statutory basis for the extensive trafficking law that has developed in the UK hitherto, the Modern Slavery Act in 2015, focusing mainly on criminalisation provisions, with the key provisions about support for victims of trafficking trafficking either not being brought into force or being left in policy, which has led to a certain degree of complexity and confusion, not least because essentially trafficking law has developed through a mishmash of EU law, case law, and unincorporated treaties being incorporated through domestic policy. So whilst many of the changes have been criticised by those representing the interests of victims of trafficking, it is at least in principle welcome that there's now a clearer statutory footing and hopefully greater clarity and specificity about how these individuals should be treated. The justification for these wide-ranging changes was set out in the Secretary of State's new plan for immigration. The UK, anyone working in this area will be used to hearing the UK's celebration of what it describes as its world-leading response to the evil of modern slavery and trafficking. But that is balanced in the new plan by the what is described as an alarming increase in the number of illegal migrants, including foreign national offenders, and those who pose a national security risk, seeking modern slavery referrals. It's perhaps worth putting those comments in the context of the Home Office's own statistics. You can see on the left of this slide that there certainly has been a significant increase in the number of NRM referrals, particularly since 2017. You'll see the the line at the top of that graph represents UK nationals being referred into the NRM, with a substantially lower number of overseas nationals being referred in. The graph on the right reflects in dark purple positive conclusive grounds decisions being made. And what you'll broadly see there is that over time, whilst the numbers of decisions has inevitably risen, the number of positive decisions has risen at a faster rate than the number of refusals, which have been quite low recently, which perhaps raises some questions about the cogency of the argument that this is a system that is being abused. The first provision I want us to look at is the requirement for potential victims to provide information to the Secretary of State on receipt of an information notice. This is perhaps not a groundbreaking provision. Victims have been required to prove their case for a long time, and that often involves the provision of copious information. However, the significant provision is at Section 59, which provides that the competent authority must take into account as damaging a person's credibility their failure to provide relevant information by a specific date where they've been required to do so by the Secretary of State, unless there are good reasons for that lateness. And that mandatory application of damage to credibility has to be seen in light of the Secretary of State's current guidance, which is issued under the 2015 Act, about the barriers to disclosure which victims of trafficking present with, the trauma and often humiliation that comes with experiences of trafficking and slavery often means that victims are not able to give in full information to a specified deadline. One would hope, given the Secretary of State's own recognition of this in her policy, that where there are barriers to disclosure arising out of trauma, for instance, that would be treated as a good reason for a failure to provide information. But as with much in this Act, we will have to see how that works itself out in further regulations, updating guidance, and of course in the courts. Section 61 and 62 place on a statutory footing the entitlement to a recovery period where a potential victim receives a first reasonable grounds decision. Those who work with victims of trafficking will note that the recovery period has now been lowered from the mandatory minimum of 45 days that was previously set out in domestic law to the minimum provided for in the European Convention on Action Against Trafficking, which I'll be referring to as ECAT, of course, given what a mouthful it is. Of merely 30 days. However, in practice, as the statute provides for the recovery period to continue either for 30 days or to the date of the conclusive grounds decision if later, it is highly likely that individuals will in practice have a substantial recovery period. The latest statistics show that the average delays for conclusive grounds decisions being made is well over 400 days. So we are looking at a substantially longer recovery period. It also disaggregates between victims who receive a first positive reasonable grounds decision and those who receive subsequent ones. This is perhaps quite a small pool of individuals, but in those cases, they are not entitled to an automatic recovery period. It is merely discretionary. I wanted to flag up in this context Article 13 of ECAT. I've already referred to the fact that it provides for a minimum of 30 days, but that is qualified by the second sentence that I've highlighted here, which says that the recovery period shall be sufficient for the person concerned to recover and escape the influence of traffickers and/or to take an informed decision on cooperating with the competent authorities. So my reading of this provision is that if the 2022 Act is to be interpreted and applied compatibly with ECAT, the recovery period would have to be tailored to an individual's needs in order to meet those requirements in that second sentence. However, everything I've just said has to be qualified by the significant provisions in Section 63, which disqualify certain individuals from protection in the UK. So after someone receives a reasonable grounds decision, they may be disqualified from protection and support where they are either a threat to public order or have claimed to be a victim of trafficking in bad faith. There is a lengthy list of criminal offences mostly, whereby individuals are deemed to be a threat to public order. No one will be surprised to know that those offences that are in the Schedule to the Modern Slavery Act as being excluded from the statutory defence under Section 45 are of course included. Most serious offences one can imagine are in there. Interestingly, whilst it's not surprising that terrorism is in there, where there are reasonable grounds to suspect someone to be a terrorist, even where that is attributable to trafficking, they nevertheless fall within the disqualification provision. However, the most significant inclusion in this provision is where an individual falls within the automatic deportation provisions, where they're a foreign criminal within the meaning of the UK Borders Act. So this is broadly anyone who has received a 12+ month sentence. There are also other categories, such as those who pose a risk to national security or who have been deprived of their citizenship. The effect of disqualification is quite radical. It means that the individual has no barrier to removal. They are not permitted to remain in the UK for the recovery period, as other individuals can, and they are excluded from leave to remain. This is obviously particularly concerning, not least because there are a number of individuals who will fall within these provisions who would have a statutory defence under the Modern Slavery Act to their conviction. And so the questions I've posed at the bottom of this slide is, are these people likely to receive a conclusive grounds decision? I would question whether they could if they're liable to removal. And if they're not receiving a conclusive grounds decision, how are they supposed to raise a statutory defence under the 2015 Act? In any event, this is clearly designed to exclude a very large number of what Secretary of State refers to as foreign national offenders from protection, from the opportunity to remain in the UK and recover from experiences of trafficking, however extreme those experiences may be, however linked to their offending, and however great their need to recover and remain in safety may be. Again, there are questions about the compatibility of this with ECAT. ECAT includes a clear non-punishment provision stating that there has to be the possibility of not imposing penalties on victims for involvement in unlawful activities to the extent they've been compelled to do so. Of course, ECAT is unincorporated and it's soft law, so there will be interesting questions again, no doubt, in the court about the cogency and impact of those provisions. Section 63, along with large other parts of Part 5, were criticised by numerous bodies, including the Joint Committee on Human Rights. And I've particularly flagged up here the JCHR's concern about the impact that these provisions will have on preventing trafficking, raising their concern that it increases the likelihood that cases will not be adequately investigated or prosecuted, and therefore that action won't be taken against organised gangs exploiting these victims of slavery or human trafficking. And perhaps unsurprisingly, they conclude that that runs counter to the UK's obligations under both ECAT and Article 4 of the European Convention. Section 64 finally sets on a statutory basis the duty to provide assistance and support to an identified potential victim. Of course, this is one who's not disqualified from protection. That assistance and support must be provided where it's necessary for the purpose of assisting the person receiving it in their recovery from any physical, psychological, or social harm arising from their experiences of trafficking or modern slavery. This broadly reflects Article 13 of ECAT, and it's welcome to have this on a statutory footing finally. The Act also, again, in welcome form, places on a statutory basis the entitlement to leave to remain for those who receive a positive conclusive grounds decision where it's necessary, essentially for the purposes set out in Article 14 of ECAT, so necessary in order to assist the person in their recovery from exploitation, seek compensation, or to cooperate with investigation or criminal proceedings. That's in mandatory terms. Once again, of course, you are excluded from this if you fall within the disqualification provisions. However, there's an important caveat to Section 65 that significantly mitigates the protection that it promises. Leave is not deemed to be necessary where the person's need for assistance can be met in their country of origin or any third country where they may be removed under a bilateral agreement. So one can hypothesize a situation in which an individual is trafficked into the UK, is brutalized, traumatized, and has extreme recovery needs, but who could, for instance, be sent to Rwanda under a further memorandum of understanding, or perhaps even on the terms of the current memorandum, which are quite broad, and they would simply be exempted from the mandatory provisions for leave to remain. I anticipate there will be further litigation on the extent of these terms, and of course they will depend on the nature and extent of further international agreements that may be entered into. Unsurprisingly, as an extension of the disqualification provisions, victims who are deemed to be a threat to public order or to have claimed in bad faith are not entitled to leave, and any leave that they do hold at the stage of receiving a conclusive grounds decision may be revoked. I thought it might be helpful at this point to put these provisions against the backdrop of the explanatory report to ECAT that states the perhaps self-evident proposition that the immediate return of victims to their countries is unsatisfactory both for the victims and for law enforcement authorities. And the purposes of the recovery and reflection period and the possibility for a residence permit in ECAT and similar provisions made in the Trafficking Directive and under Article 4 is both in the interests of the victim to recover, to maintain some stability, but it's also in the interests of states seeking to end the evil that is modern slavery and trafficking, because the more stable an individual is, the more willing they are to come forward, the more safe they feel if they do come forward, the better assistance they will give to law enforcement authorities, and the greater possibilities they will have both to recover and to assist in prosecution. Therefore, I think one can fairly raise the question as to whether these provisions, if brought in with their full rigour, will in fact assist the Secretary of State's stated aim of combating trafficking. I've just mentioned the Trafficking Directive, and very significantly, this Act disapplies the retained EU law under the directive insofar as incompatible with these provisions. That is significant because a number of the provisions I've just described are flatly incompatible with the Trafficking Directive. And unfortunately, for those representing victims of trafficking and modern slavery, recourse to EU law is likely to be impossible where there is a conflict under this Act. For those who may be here who represent victims of trafficking and modern slavery who are now weeping into their cereal, there is a small consolation at the end of my talk, namely that these provisions are not yet in force. As Admas mentioned in his talk, large parts of the Act are not yet in force, or insofar as they're in force, they're only in force for the purposes of making regulations. However, they can be brought into force at any time, and therefore practitioners have to be continually refreshing Westlaw or whatever your professional tools are. Indeed, since I finalised these slides, the Secretary of State has yesterday laid the draft Slavery and Human Trafficking Definition of Victims Regulations 2020, which seek to define and I believe also potentially to narrow the definition of victims for the purposes of this Act. Essentially the definition of slavery under the draft regulations appears to broadly correlate to the definition within Article 4. However, the definition of human trafficking appears to be substantially narrower than the definition under ECAT. In particular, there's a focus on travel. And so there appears to be some sort of requirement of movement, potentially even international movement, in order to fall within that definition. I'll leave it to those attending to read the regulations themselves and see whether they agree with my definition. Thank you very much, everybody. I think we've now got some time for some questions.
Right, thank you, Miranda, and thank you also to Joe and Admas. That was a vast amount of very cogent and detailed information in a relatively short space of time. So short space of time, in fact, we've got quite a bit of time left over for questions if we need it. So we've only got one question so far in the chat that I can see. Just before it comes to that, I mean, obviously what emerges from that is, in many ways, to my mind at least, a pretty troubling and, I don't mind admitting, depressing picture. The other point that really struck me was how uncertain a lot of it is. I mean, there's an awful lot of litigation. I think there's quite a lot of reference to future litigation to find out what all of this means in practice. And I think that's probably also true of some of the stuff that was talked about last week on things like the standard of proof. So more work for lawyers, but in this case, not stuff that I would necessarily welcome. I mean, I'd be very pleased to do the cases, but I mean, to say that it's perhaps sad that we have to do it. There it is. So we've had one question in the chat, and that's a question about the nationality provisions, which is clearly, I think, a question for Admas, who's already assured me he's raring to go. So I shall just, it's from an anonymous attendee. A question I'll just read out. Under the old nationality, I think the old legislation, under the old nationality good character requirement under the heading immigration related matter indicated if they have breached immigration laws, for example, by overstaying, working in breach of conditions or insisting in the invasion of immigration control, their application for naturalization falls for refusal. I think that's, would that be a reference to a policy document? I'm not 100% sure.
Yeah, it's a guidance document.
Yeah. So in any event, the question is then, in light of that, what is the position in respect of the above under the new provisions? Over to you, Admas.
I think my answer is quite simple on this. As far as I understand, the Act doesn't introduce any change to the substantive requirements of what constitutes good character. It just extends that requirement to certain new classes, mostly in relation to those examples I gave where they were where the Act extends the right to register to as a British overseas territory citizen. So there's no substantive change.
Thank you. I hope that's a good, full answer to that. That's as I'd have imagined. We've got a new question, actually. It's a very good question, a very good practical and important question. I wonder if we know the answer yet. It's a question for you, Joe, about age assessments and the role of the FTT. So the question is, do we know how the age assessments in the FTT will be funded? public funding certificate or controlled work. Joe, do we know the answer to that, or is that a matter for probably legal aid related legislation?
I suspect it is a matter of legal aid, legislation. At the moment, I don't know the answer to that, but I'm happy to go off and research it and come up with a clear answer on that one.
No. Does anyone, I mean, I'm not suggesting you should, but do either of the other members of the panel know the answer to that? No.
No, I'd be very surprised if the regulations had been amended yet.
Yeah, yeah. All right, so sorry that we don't know the answer to that. Watch this space, I'm afraid. Oh, another new question's popping up. People are now asking them. So let's see. I think this is, well, I'll read it out. How does the new provision in relation to revoking leave without notice reconcile with the public law principles of procedural fairness? Is it likely that the courts will interpret this narrowly? Admas, is that question for you?
Yeah, I mean, I was looking at the provision on depriving a person of nationality without notice. So in relation to that, will the courts interpret it narrowly? Ordinarily, you would expect the courts to interpret a provision like this quite narrowly, given the starkness of its evisceration of procedural rights. But I mean, at the moment, I am struggling a little bit to see how it could be watered down simply as a matter of interpretation. I expect that it's going to be a more substantive argument that is more likely to leave a dent in it if successful, just because the terms of it are quite clear.
I suspect it was drafted against the background of the Home Office's experience of the court's interpretation of these provisions and drafted in a way to avoid that sort of thing. And the other thing, again, sad to say from my perspective, is that bearing in mind we're dealing in part with issues of national security here, the recent approach of the court in Begum may suggest that its willingness to cut down on these kind of restrictions is less strong than its commitment to those principles is less strong than it used to be. But in any event, it may be, as Admas says, there's no scope for that. I mean, the other thing we've got to recognise is these are provisions of primary legislation. And there are limits to what the courts can do, certainly if there's no room for reinterpreting them. That was something that occurred to me actually when I was listening to Miranda's talk as well, in relation to the problems, the issues which may arise with the compatibility of this legislation with ECAT, because of course ECAT is not, well, I mean, there are extents to which it's incorporated, but it's not incorporated in any general way. And I don't think you could say it's incorporated in a way that would allow you to directly equivalent to the do anything equivalent to the Human Rights Act. I mean, that doesn't mean to say it would be irrelevant to its interpretation. It will be, I think, relevant to the interpretation, but that's the limit of it, and it's got quite a soft role to play. So those points about it being incompatible, they're very important points, and they're points that need to be put forward, but it may not be a full frontal assault. It may be difficult both here and in relation to the provisions that Admas was talking about.
Yeah, can I just make another point, actually, Tim? Sorry.
While you're doing it, I'll work out. The questions are coming in thick and fast now. So you go.
I just while looking at the provision again, something did strike me is that if the requirements are met, then the Secretary of State can say that notice should not be given. But actually, under subsection 5, the Secretary of State's got to give notice as to the order, the reasons for it, and the right of appeal. So I can imagine that different arguments would arise as to giving notice for the reasons versus giving notice of the fact you've made a decision. So it may be that there'll be a greater scope for the Secretary of State to argue that they oughtn't to give notice of the reasons in light of national security, but there may be a higher threshold for not giving notice of the order at all. That seems to me one interpretative possibility.
Yeah. So we've had a couple of other contributions. In fact, one of them is Jen Parker saying something about legal aid, which I'm going to park for a minute and try and pick apart for myself and come back on it. In the meantime, there's another question, which I think is a question for Admas. A little confused about the introduction of provisions for people to register as British based on their parents not being married or their mother not being able to pass on the nationality. nationality. Does this replace or simply clarify the current UKM and UKF applications people can make to register on that basis? That is a question for you, I think.
Yeah, I'm sorry if I'm being dim, but what does the UKM mean? Well, what they do is they essentially take the criteria, pre-existing criteria for registration as a British overseas territory citizen, and they say that you can meet those criteria, notwithstanding if the only obstacle was the fact that your mother wasn't married to your biological father, or that you only would have acquired it through your mother. That's really the long and short of it.
Yeah. All right. And that's quite an important issue. I did a case some years ago about people who had adopted the nationality of the person to whom their mother was married, even though they were separated at the time. And since he wasn't British, they lost out on the opportunity to acquire nationality. So this is a further move in the kind of long march of trying to correct those sorts of historical injustices. Just coming back to the legal aid provision, I'm just going to try and so Jen says that so it looks as though the issue of legal aid for age assessments may have been dealt with. Is that right, Jen? Please say if I've got this wrong, because I'm not going to try and pick apart this provision in great detail now, but it's what looks like, is it Regulation 57 of the...
I was trying to pick apart it myself whilst Admas was asking the previous question. What I do know is that Section 57 of the Nationality and Borders Bill adds age assessments to Schedule 1 of the Legal Aid Sentencing and Punishment Offenders Act. How that plays out in terms of contracts and payment, I haven't got to the bottom of yet.
All right, so fine. I don't think we've got a full answer. Sorry, barristers never know the answer to these questions. I'm afraid it's always solicitors who are on top of those details. I apologise for that. Okay. All right. So that is, I think, all of the questions we've had. We've got a little bit of time left, but let's call it a day there. Thank you very much for attending. I hope that was as informative to you all as it was to me. And we'll give you a way into thinking about these important new provisions. Miranda,
I think we've just had one more question in the chat about trafficking.
You want to take it?
Obviously, I'm always keen to talk about. An anonymous attendee talks about an example of where a client, such as a child, displays trafficking indicators but is unwilling to make any disclosures or agree to any psychological assessment prior to the deadline given by the NRM. How would you recommend approaching this evidentially to avoid negative findings due to late disclosure? I think that's a very fair question. I think there will be a lot of cases where this sort of thing arises. I would hope that the Secretary of State's guidance, when published and amended, when these provisions come into force, will recognise for instance, the principles that I've cited in my talk about barriers to disclosure. I think evidentially you'd need to look at broad background information on barriers to disclosure. And what I would suggest doing in these situations is to preemptively approach the Secretary of State and say, look, we think that it's going to be impossible to obtain disclosure in time, and to ask for additional support. Because if this is an individual who's received a positive reasonable grounds decision, which in most cases it will be, they should be individuals who have a support worker and also have entitlements to needs-based support. So if it's the case that they require greater stabilisation, financial support, psychological support in order to get to the point of making disclosures, that's something you can and should ask the Secretary of State to provide.
Yeah, good. That sounds like good advice to me. All right. So thank you again all for attending. I hope it was useful, as I say, and I think the slides will be, I hope I've got this right, sent to you as attendees in any event, and a link to the seminar, which was also available on the website. Thank you again, and we'll end the session there. Thanks.